Welcome and thank you for joining Seifart's webinar, the 2023 California Employment Legislative Update. All participants are in listen-only mode, but are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Christina Lani.
Hello, everyone. Thank you for joining us. As you can see here, we just passed by that first legal disclaimer slide. We are here to give you information, no legal opinions. That's about what you need to know from this slide. On the next one, however, you can see the panel of us who will be speaking with you today. As you can see, the outside here is fighting against me. So luckily, I'm just going to introduce Kobe and Kathy, who are going to really get into the meat of the new California laws that you all need to be prepared for 2024. As you can see, there we are, both live and in photo. If we go to the next slide, however, it will help us see the general categories of what we're going to talk about today. In prior years, as you all know, we usually put by subject area the different new laws that you're going to need to know about. Believe it or not, there weren't a lot this year. I mean, there was a lot of legislation that flowed through the process, but in terms of the bills that actually were signed into law by the governor, we have a couple of doozies having to do with non-competes. We have another paid sick leave bill, as always. But on the whole, not a lot of bulk this year. So we're going to talk about what you need to prepare for January 1st, 2024. And one exception, I think there was only one law that's already gone into effect. And then we'll talk about what bills the governor vetoed, because it's highly, highly likely those bills will be back again. And then finally, what bills did not make it through the legislative process this year, but will in all likelihood be back again. On the next slide, you can see the key dates that we've been through in this legislative year. They're all done, other than the new bills that will become laws going into effect January 1st, 2024. The legislature will reconvene at the beginning of December for the second year of the 2023-2024 session. And as I said, some of the bills that we're going to talk about that did not become new laws will likely either be back or continue through the process. But until then, we will move on to Kathy and Kobe telling you about those new laws that you should be thinking about how to prepare for January 1st, and anything else you should think about to make sure that you're all ready to go under whatever new California peculiarities we have in store for you. So with that, Kobe, you want to dive in?
Yes, thanks, Christina. So let's get right to it, Brenda. If we could go to the first slide. Thank you. So the first thing that employers need to be aware of out of this legislative session is SB 497. It creates a rebuttable presumption of retaliation if you are engaging in an adverse action, meaning something like a discharge or a threaten to terminate, demotion, suspension, things of that nature, within 90 days of an employee making any complaints or claims related to rights that are under the jurisdiction of the labor commissioner, which basically means anything having to do with unpaid wages, missed meal and rest periods, that sort of thing, anything you might think of as your typical kind of class action labor code type claims, as well as any kind of complaints about equal pay violations, like I'm not getting paid as much as my male comparator, I'm not getting paid as much as my comparator of a different race or ethnic group. So in the state of California now, that means that if those complaints are happening and you engage in any kind of adverse action within 90 days, it will be upon the employer to prove that the adverse action was not as a result of the complaints, which is a tough bar to cross, especially where for many employers, you oftentimes don't get these complaints from people until they already are being performance managed, and then suddenly these complaints come out of the woodwork. So employees will be well aware of this when they're trying to make sure that they're not going to be getting terminated. So something to keep in mind. You want to the extent you have HR procedures in place about, questions before you terminate someone, you're doing your check down red flag list. You want to make sure that you're adding this to that list. Has somebody made any of these complaints within the last 90 days? And if so, have we well documented the reasons for the termination prior to these complaints, or the demotion or the adverse action otherwise? The other thing that this statute does is that it expands the penalties dramatically under the whistleblower statute, which used to be a single penalty against the employer of $10,000 for a violation, up to a $10,000 penalty per employee. So if, for instance, you're engaging in like a number of terminations, or something of that nature, the amount of penalties can be much bigger. The labor commissioner, however, does have discretion to reduce the penalty based on the evidence that comes out in the investigation. So it's not like a fixed fine, but still it provides plaintiffs' attorneys with some leverage when they are threatening these kind of lawsuits, especially in a pre-demand context. Just as a, can you hear me? Did I freeze for a second? Okay, sorry. Just as a reminder of the current provisions, when I say complaints, I don't mean that they have to file something with a legal entity. A complaint can be internal or external. It can be oral or written. So either type of complaint would work to satisfy the predicate under this statute. And it's not just where the employee has personally made a complaint either, because retaliation is also prohibited under the statute where their family member has made a complaint or has been perceived to make a complaint. Next slide, please. PAGA updates under AB 594. What this statute does is right now, PAGA is officially only allowed to be prosecuted by the Labor and Workforce Development Agency, and to the extent that other types of prosecutors want to be bringing cases like this, it has to be done under the auspices of the DLSE, which is the state agency that runs labor code investigations and complaints. This new law dramatically expands the ability of public prosecutors like district attorneys, city and county attorneys and prosecutors, or the attorney general to prosecute violations of the labor code without the oversight and involvement of the DLSE. So for those of you that have dealt with PAGA lawsuits in the past, you are probably well aware that the LWGA and DLSE basically never, with rare exception, actually investigate complaints that are brought to them. This gives a much broader swath of prosecutorial authority in order to do that, in basically recognition that the DLSE and LWDA are overwhelmed and underfunded. And the stated intent of the bill is to help fight against wage theft, which the state feels like is expanding. This also states that arbitration agreements that you may have with your employees, not under CBAs, but individual arbitration agreements or otherwise agreements you may have with your employees that may limit their rights to bring representative or collective actions. This law specifically states that those do not apply to prosecutions under this law by the public prosecutors, which has been to date somewhat of a question of law, like could the state bring agreements on behalf or bring cases on behalf of employees with arbitration agreements. This officially says that they cannot. It allows for any of the same sort of remedies under PAGA that could otherwise have been gotten by the LWDA, so injunctive relief, reasonable attorney's fees, costs, witness fees, etc. It also provides that, I suppose this is a slight upside, is that it provides that penalties for the misclassification of employees, which are quite stiff, may be recovered by an employee under either Labor Code 98 or PAGA, but not both, and also by the Labor Commissioner as a civil penalty. So this makes them elect their remedies. They can't both sue you under the Labor Code and have a PAGA remedy. So small green light, we'll take what we can. And for those of you that are wondering about the current PAGA ballot initiative that we discussed last year, which we thought would be on the ballot last year, the ballot for the PAGA reform initiative is actually qualified for November 2024 at this point. So we suspect that at least some of this law was prompted by the prospect that there may be this PAGA reform initiative that Cal Chamber has sponsored that would be limiting private plaintiffs' ability to pursue PAGA lawsuits. And then, in response to that, they're thinking, how can we continue to prosecute these wage theft violations? Well, if private plaintiffs can't do it, then we want to make sure that, I say we, meaning the government wants to make sure that there's other agencies and individuals that are able to prosecute those in the event that that ballot measure passes. Next slide, please. Non-compete agreements. So here we have two different bills that were passed this legislative session, Senate Bill 699 and Assembly Bill 1076. They have some overlapping provisions, so we combined them here for purposes of this slide so you just can understand the overarching concept of what happened between the two of them. So the first one was AB 1076, was SB 699, which makes any contract that is void as a restraint on trade, basically non-competes, unenforceable regardless of where and when the employee signed the contract. So if you have an employee that started working for you in Texas 5 years ago and signed a non-compete that is fully enforceable in Texas, and then they relocate to California, that agreement is no longer enforceable the minute they hit California's borders, basically, under this new law. This applies no matter how narrowly tailored your non-competes were. So even if
Oh, it looks like we lost Kobe there.
sorry, can you hear me?
Yep.
Sorry, I knew that was coming. My VPN cut out. Apologies to those of you on the webinar here. And so this applies to individuals with very limited exceptions. The exceptions are basically like if you sell your own business and the goodwill of your business, or you leave your partnership in your LLC, those tend to be the only exceptions to where non-competes are valid. And so this would void any contract containing those kind of provisions, even if the person being restrained is not a party to the contract necessarily. This also prohibits employers from entering into contracts that have non-compete provisions with current or prospective employees in the first instance, and doing so is a violation of the Civil Code and can also be used as a predicate for PAGA violations and in a number of lawsuits, which we have seen with increasing regularity in the last couple of years. It also prohibits employers from both entering into these agreements or attempting to enforce them. So if you have a client that wants to or if your in-house people are prompting you to send cease and desist letters for violations of non-competes, you want to think very carefully about that, because even sending the cease and desist letters can be in and of itself a violation under this new statute that may entitle the employee to injunctive relief and damages, attorney's fees, etc. Also, AB 1076, which was the second of these laws to pass, is a bit broader. It basically codifies some existing case law that says that non-competes are unenforceable in California. But what AB 1076 does, which goes a bridge farther, is that it requires an affirmative notice to current and former employees by February that any kind of non-compete clause or agreement that they may have entered into and previously signed is now void. So what this means is that where you have employees that may have relocated since they signed non-competes, maybe they signed them outside of California and you just haven't done anything about the ones that they signed that are in their personnel files and that sort of thing, you need to affirmatively reach out to them and let them know by February that those provisions are no longer enforceable, that they are void. And so a violation of the act is an act of the act is considered to be unfair competition under the Business and Professions Code. So actually even just doing that could be a violation of the law. Now, practically speaking, are your employees going to be digging through their old personnel files and realizing they didn't receive this notice by February? Probably not. But where this is going to be coming up is in the context of class actions where this becomes a tag-along claim. And particularly for those of you that may get personnel file requests and you're producing things in the personnel file that people signed, including potentially these non-compete agreements, you need to be very cautious if you're doing that you have made sure that these employees have been informed by February that those provisions are no longer enforceable, that they're void. And in the context of producing those personnel file records, you should anticipate some pushback from plaintiffs' counsel, hopefully not in the context of a class action, but possibly about these unenforceable agreements. You may even want to go back into the file and just like write void in big black letters on top of it at this point so that there's no question mark about what you are doing with those old agreements. Next slide, please. Stay pending appeal from arbitration agreements. So for those of you that currently have arbitration agreements, many of you may be moving to enforce them, particularly where you have class and collective action waivers and you have been hit or threatened with lawsuits in that regard. Right now, the California Code of Civil Procedure has a mandatory stay provision. So if your motion to compel arbitration is denied, the court is required to stay the action while the appellate process plays out. In response to some significant lobbying from the plaintiff's bar, this law passed, which eliminates the current rule automatically staying trial court proceedings pending the appeal of a denial from a motion to compel arbitration, which means that the leverage point that employers have right now of moving to compel arbitration, knowing that even if you lose, you might be able to appeal and tie the case up for 18 months, is going to be going away as of the first of the year. This also means that going forward, employers may have to be actively defending lawsuits in court while they're waiting for the process to play out about their arbitration agreements, which is obviously not ideal. What this also means is that if you are thinking about moving to compel arbitration, and you think, especially if you think that you either have a judge that's going to be very critical or that there may be potentially some weaknesses in your arbitration agreement, you want to be doing that now because your ability to appeal and stay the case will go away as of January 1st. So you have like 2 months to get those motions heard and still file an appeal and get an automatic stay. And for most employers, that's a key part of the strategy of moving to compel arbitration. So now basically all this does is it makes it discretionary whether to stay proceedings with the trial court rather than a mandatory statutory stay. And as you guessed, what you're probably going to see is forum shopping with plaintiffs who are going to selectively bounce judges in state court that don't automatically stay the case. They're going to be filing in courts where they know they're more likely to get judges that will proceed with the case, even if they potentially the question about the enforceability is off. So what this means is please double check your arbitration agreements now. Make sure that the language is as compliant as it can be so you don't have unenforceable provisions like serious restraints on discovery or statute of limitations that would make the agreement unconscionable. And also, to the extent that you don't have it in your arbitration agreement now, which probably many of you don't because this hasn't been an issue before, is consider whether you want to incorporate mandatory stay language into the agreement itself, meaning that you put in the agreement that in the event that there is a dispute about the arbitration agreement and there is an appeal pending, you put into the agreement that both parties agree to stay the action while the appellate process works its way out. Now, whether or not a court will actually enforce that part, question mark, but it certainly couldn't hurt. So we're recommending that as you are going forward making those revisions that you consider encompassing that language as well. And I think we're going to go from there over to Kathy.
Thanks, Kobe. All right, so we are going to tackle some changes that have been made to paid sick leave law in California. What this bill primarily does is it increases the annual paid sick leave usage cap from 24 hours or 3 days each year to 40 hours or 5 days. And that is going to be the case whether or not employers are accruing or front-loading paid sick leave for their employees. This seems like a big increase, but really what it's doing is aligning California with a number of other state paid sick leave laws, including Arizona and Massachusetts, Oregon, just to name a few. So we're really just stepping up our game in accordance with other states. It's also increasing the rolling accrual cap and max accrual cap from 48 hours or 6 days to 80 hours or 10 days. For employers that want to provide a front-loaded grant and avoid accrual and carryover. In order to do that, they're going to now need to provide new employees with no less than 40 hours or 5 days of paid sick leave. And for new hires, that grant must be available by their 200th calendar day of employment. The bill is also extending the current anti-retaliation and procedural provisions to include those covered by a valid collective bargaining agreement, and expressly excludes railroad carrier employers and their employees. One bright light is that it preempts certain provisions of local ordinances that are going to be contrary to the state law relating to payout on separation, lending of leave, written notice of leave, and other administrative issues. Employers are definitely going to want to take a close look at their policies on paid sick leave. Most likely there's going to need to be changes there. And also take a look at your wage theft notices, make sure that those are compliant with the new accrual requirements. And with any changes that you're going to be making to these, also make sure that you're checking your employee wage statements, or if there's a separately issued document that you're issuing showing the amount of sick leave available, you want to make sure that those are showing the updated accruals based on this new law. Next slide, please. All right, so another leave provision this year was leave related to reproductive or adoption loss. This is it applies to a wide range of employers. Basically, anybody with at least 5 employees who've worked for at least 30 days will now be entitled to 5 days of unpaid leave related to a reproductive loss event. And employers can't refuse to grant an employee's request for this leave if they have experienced a miscarriage, a failed surrogacy, a stillbirth, unsuccessful assisted reproduction, which would be an embryo transfer, for example, or a failed adoption. You might be wondering, given the wide type of events that this covers, if you can request documentation. While the bill doesn't expressly state whether documentation can or can't be requested, it's more than likely prohibited here. We saw in the bereavement leave law for California that it expressly said that documentation could be requested. Here, because the bill is silent, the safest route is going to be to assume that you cannot request documentation. If an employee suffers more than one event that would qualify for this type of leave in a 12-month period, they are capped at no more than 20 days of leave related to that. And while leave doesn't need to be taken consecutively, it does need to be completed within 3 months of the reproductive loss. And as with a lot of bills, this one also prohibits retaliation against an individual who uses this leave or shares information about the leave, and employers are required to maintain employee confidentiality relating to reproductive loss leave. Next slide, please. All right, so moving into AB 933, this is our harassment and defamation privilege. So prior to this bill, we had California Civil Code Section 47, which designated certain types of publications and communications as privilege and protected the makers of privileged statements from defamation lawsuits, even if the statements had a tendency to damage someone's reputation. AB 933 is expanding the definition of a privileged communication to include communications made by an individual without malice about the individual's own experience of sexual assault, sexual harassment, workplace harassment, or discrimination, and cybersexual bullying. And what constitutes a communication has a pretty broad definition here. So it's going to be factual information relating to an incident of sexual assault, harassment, or discrimination experienced by an individual who's making the communication, including acts of sexual assault or harassment, acts of workplace harassment or discrimination, failure to prevent workplace harassment or discrimination, aiding, abetting, inciting, compelling, coercing workplace harassment or discrimination, and of course, retaliation for reporting or opposing harassment or discrimination. Another thing to look at is who qualifies as an individual making the statement, and here the privilege is going to extend to any individual who could have at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination even if no such complaint was filed. And while in most defamation cases, prevailing defendants are not entitled to recover attorney's fees, here, that's an available remedy as well as treble and punitive damages. All right, next slide, please. So this is another one dealing with harassment in the workplace. So beginning on January 1st of 2025, so you've got a little bit more leeway here before it goes into effect. SB 428 is going to be in effect. Under the current law, employers can seek TROs and injunctions against an individual who's engaged in workplace violence or threats of violence against employees. But what this law does is it allows employers to now also seek TROs and injunctions against an individual who has harassed employees. And you can see here on the slide the definition of harassment. So a little bit different than just the legal definition of harassment here. Basically, the reason for this law, what supporters were really touting, was that employers shouldn't have to wait for conduct to escalate to an act of violence before seeking court intervention. One important limitation is that a court can't issue an order that would prohibit speech or activities that are protected by the National Labor Relations Act or otherwise protected under another provision of law. Next slide, please. All right. So continuing our theme of workplace violence, we're going to take a look at SB 553. And this is a big one. It's going to be requiring most California employers to create, adopt these written workplace violence prevention plans by July 1st of 2024. So again, a little bit more leeway, nothing by January of this year, but coming up pretty quickly. This is going to cover, again, most employers. The types of employers that are not going to be required to have these plans in place are employers who are already covered by Cal OSHA's violence prevention in healthcare standard. And if you've got employees who are teleworking from a location of their choosing outside the control of the employer, or locations that aren't open to the public where fewer than 10 employees work at a given time. But other than that, most employers are on the hook here. And the plans have to be in writing and easily accessible to employees and have to include a whole variety of things. We've listed some of them here on the slide, but you're going to need to be including a lot of different procedures for implementation and training on the plan, as well as how to communicate with employees about reporting violent incidents, how those incidents are going to be investigated, how results are going to be communicated, how employers are going to be identifying and evaluating the workplace violence hazards, and violent incident logs. Violent incident logs is something that the bill goes into a lot of detail on. Basically, employers are required to record every workplace violence incident in a log and retain those records for at least 5 years. I apologize for the dog in the background. She loves to do this whenever I'm on a presentation. So for those of you who can hear her, my apologies. There's other provisions within this law that are also subject to the same 5-year record retention requirement. That would include workplace violence hazard identification, evaluation, and correction records, as well as the records of workplace violence incident investigations. The bill also has specific training requirements that employers are going to have to comply with, both when the plan is first established and annually thereafter. And there's very specific topics that need to be addressed. Those training records also need to be retained, but luckily only for 1 year, not the 5 years that we have for the other categories of records under here. And a big question that's come up with this bill is whether or not Cal OSHA is going to publish a model program for the workplace violence prevention plans. Chances are very high that we will see that happen, even though it hasn't been made clear yet that will definitely be happening or not. So keep an eye out for information on that. And another thing that this bill does, as though it didn't already do so much already, is that it also addresses restraining orders and permits a collective bargaining representative, not just an employer, to seek a TRO on behalf of union members. So this is allowing even more relief for employees who are faced with threats of violence and actual violence. And it allows employee names to be withheld from TRO papers, which gives them increased anonymity. and it expands on the actionable conduct necessary to give rise to a TRO. So a whole lot is happening with SB 553. Definitely pay attention to that one. And we can move to our next slide. All right, so switching gears a little bit, AB 1355, this is our electronic notices bill. And this bill does a few different things as well. So first, it amends section 19853 of the Revenue and Taxation Code to redefine how employers can send their employees notifications regarding eligibility for certain federal and state tax credits. Under existing law, employers have to send notifications twice a year. The first notification has to be hand-delivered or mailed to an employee's last known address, and the second notice could be sent electronically. But under AB 1355, the first notice can now also be sent electronically until January 1st, 2029, when the law sunsets. In order for that notice to be sent electronically, employees need to provide consent to receive electronic notices, either in writing or by some type of electronic acknowledgement. And the bill also amends Section 1089 of the Unemployment Insurance Code to allow employers during that same period of time until January 1st, 2029, to send unemployment benefit notifications electronically as well. Again, there needs to be some type of acknowledgement from the employee before doing so that they're consenting to the electronic transmission. And if the consent is provided by an electronic acknowledgement, it has to fully explain that the employee is agreeing to electronic delivery of the notification, provide the employee with information about how they can revoke consent, and create a record of their agreement. So definitely some documentation to be created there to ensure that you're not just moving straight to providing the electronic notification, but you're complying with that consent piece as well. Next slide, please. All right, so we're going to move into our industry-specific bills, and there are a few key ones there. So on the next slide, we're going to start with one that's already gone into effect. This is SB 41, and it went into effect on the day that it was signed, March 23rd of this year, and it requires that airline cabin crew employees covered by CBAs with meal and rest break provisions can be expressly exempt from California's meal and rest period requirements. SB 723 that we also include on this side, that's our right to recall in a hospitality bill. And this one was signed towards the end of the legislative period, and it moves the expiration of the right of recall rights for employees in hospitality and service industries from December 31st of next year to December 31st of 2025. It also adds a presumption that a separation due to a lack of business or a reduction in force or other economic non-disciplinary reasons would be due to a reason related to the COVID pandemic. And it applies to a variety of industries, obviously all under the umbrella of hospitality, but including hotels, private clubs, event centers, airport hospitality operations, building services to office, real or other commercial buildings. So if that's something you think might apply to you, definitely make sure you're paying attention to those changes. And now we're going to move into one that impacts our healthcare employers on the next slide. And this is SB 525. So this is another big one that covers a wide range of healthcare employers and healthcare employees. Again, going into effect of June of 2024, so coming up quickly, but not as quickly as January. And what this bill primarily does is it's going to be increasing minimum wages for California healthcare workers to at least $18 an hour. Most healthcare employers are covered under this bill. There are a few express exemptions. For example, hospitals that are owned, controlled, or operated by the State Department, tribal clinics that are exempt from licensure, outpatient settings that are conducted, maintained, or operated by a federally recognized Indian tribe, tribal organization, or urban Indian organization. But other than that, almost every type of healthcare entity and employer is subjected to this. And similarly, most employees are going to fall under the definition of a healthcare worker. That includes employees who are providing patient care, healthcare services, or services supporting the provision of healthcare, which obviously includes individuals such as nurses or physicians, but also includes gift shop workers, janitors, schedulers, and billing personnel. So again, this bill has a very, very expansive umbrella of who is covered under it. So very important to pay attention to those expansive definitions to make sure that you're complying with the new minimum wage requirements across the board. Within the bill, there are 5 separate minimum wage schedules that depend on the nature, size, and structure of the employer's business. So this doesn't say that everybody starts at $18 an hour. There are different schedules that, again, need to be paid close attention to make sure that you're complying with the correct bucket that those types of employees and employers fall into. And one important thing to keep in mind with this is it impacts not only your non-exempt employees, but also exempt California employees as well, to the extent that those employees would qualify as covered healthcare employees. So under the bill, exempt employees will have to earn a monthly salary equivalent to no less than 150% of the applicable healthcare minimum wage, or 200% of the state's generally applicable minimum wage, whichever is greater, in order for them to qualify exempt under California's laws. So that's another, big change to be paying attention to here. And one kind of bright light here, one small piece of consolation, is that the new legislation does provide that no city, county, including charter cities, can enact any ordinance or regulation that relates to wages or compensation for covered healthcare employees before January 1st of 2034. So at least here, you won't have to deal with local ordinances that are further complicating the minimum wage and wage requirements for healthcare employees. And we can move now to another one dealing with the fast food industry. So for those of you, some of you might remember that last Labor Day, Governor Newsom had signed AB 257, which was the Fast Recovery Act. And that was slated to go into effect on January 1st, 2023, but immediately after it was signed, the Save Local Restaurants Coalition submitted over 1 million signatures in support of a referendum to overturn that law. And they subsequently filed a lawsuit and obtained a preliminary injunction preventing the Fast Recovery Act from going into effect, pending completion of the referendum process and some other requirements if the referendum petition ended up qualifying for the ballot. So what AB 1228 does is it repeals that existing suspended law and will establish the Fast Food Council within the Department of Industrial Relations if the referendum is withdrawn by January 1st, 2024. Excuse me. So this does similar things to the first Fast Recovery Act, but with some few critical limitations. It does still establish a Fast Food Council, but that council is a lot more limited than under the prior iteration of the law. So first, they, excuse me, are limited to developing and proposing minimum employment standards, with the exception of minimum wage increases, which they are able to set. Other than in their role of developing and proposing employment standards, there's also a lot of limitations in terms of how those standards might ultimately be adopted. So they're proposals only, which are then made to a California agency that has some type of rulemaking authority. And the agency then has discretion. Depending on the agency, it varies about what to do with those proposals. So for example, for standards that relate to workplace safety or other matters that might fall under Cal OSHA's jurisdiction, Cal OSHA has full discretion to decide whether to implement any standard recommended by the Fast Food Council pursuant to a petition process. A similar process is required for standards that relate to discrimination, harassment, or other matters that might fall under the Civil Rights Council's jurisdiction. And standards that relate to any other topic would then go to the Labor Commissioner that would have to go through a formal rulemaking process in order to enact the proposal. So they don't have as much freedom as the prior iteration of this law had given them. And an important thing to note here is that this is really intended to apply to national fast food chains that are primarily engaged in providing food and beverages for immediate consumption on and off premises, where patrons order select items and pay before consuming with limited or no table service. And why I go through that whole definition is because there are obviously different employers, different businesses that do have some type of fast food element, but it's not necessarily what they're primarily engaged in. So if you don't specifically satisfy that primarily engaged in requirement, you likely are not going to be subject to this bill. So definitely, if you have questions about that, reach out to your favorite Seyfarth attorney and we can guide you as to whether or not you're subjected to this. Another limitation that is important to note here, when this iteration, AB 1228, was first introduced, it did contain a joint employer liability provision, which would have had franchisors sharing in the same responsibilities and liabilities. But as part of a compromise that was reached between Governor Newsom and the Save the Local Restaurants coalition, that provision was tossed. So I like to end these slides with a bright light for some people. One other fast food related bill to just mention, it's not on the slides here, but SB 476 was a food handler card expenses and requirements bill that did pass. And that one's going to require an employer to pay costs associated with an employee obtaining a food handler card, including the time that it takes for the employee to complete the training. All of that time would be considered hours worked, and the cost of the food handler certification program, and at the time it takes to complete the certification program. The bill also prohibits an employer from conditioning employment on an application or employee having an existing food handler card. So a few key things happening for the fast food industry to pay attention to as these are going into effect. And with that, we're going to move to the next slide, which covers successor grocery employers. This one's a little less meaty, but still meaningful. So existing law establishes that grocery worker retention provisions requiring the buyer of an existing grocery store have to retain employees for a 90-day transition period. And during that period, employees can only be discharged for cause and have to be considered for continued employment at the end of the transition period. This AB 647 places a new requirement on their hiring and reinstatement rights when there's that same change in control. It expands the definition of a grocery establishment to include distribution centers regardless of the size. And while the prior law had excluded retail stores that ceased operations for at least 6 months, this new law limits that exclusion to stores that ceased operations for no less than 12 months. There is a relatively narrow exemption here for grocery employers and successor grocery employers that collectively employ less than 300 individuals. So again, that's not looking at whether just one, whether the successor grocery employer has 300, but it's got to be both of them collectively. So a pretty narrow exemption there. And with that, I'm going to toss it over to Christina to talk about our vetoed bills.
Okay, thank you, Kobe and Kathy. So lest you all think that you can just jump off, I will let you know that while I am very quickly going through the veto bills and the bills that did not even make it to the governor's desk, we will, in the middle of that, give you your CLE code. And while I'm doing that, Kathy and Kobe will look through the many questions you all have sent in, and we'll see if we can answer a couple of them at the end before we sign off. So stay tuned, and I promise I will keep the veto bills very quick. So the first two here. The first one is the Family Caregiver Anti-Discrimination Act. This one would have essentially added family caregiver status as a protected class under FEHA. That one did not make it past the governor's desk and into law. The second is adding caste as a protected class. You all probably read about this one. It was very much in the news, was very controversial. And ultimately, this one will not become a law in 2024 either. It would have attempted to clarify existing law prohibiting caste discrimination as a type of ancestry, and it would have defined ancestry and defined caste, both for purposes of FEHA related to employment and the UNRRA Act related to customers, essentially. The next bill that was vetoed on the next slide is, this one's fascinating. This one went through a variety of iterations as it went through the process. Ultimately, and the reason why you have so much text on this slide is because the ultimate version of the bill that went to the governor's desk and that the governor vetoed had this very specific notice that is in quotes here on the slide, that an employer would have been required to provide to any employee who is working remote, who the employer wants to say, hey, you got to come back into the office, no more working remote. The law would have required the employer to provide that employee this notice 30 days in advance of when the employer would want the employee to come back to work. And the notice essentially informs the employee that the employee has the right to ask to continue to work remotely as a reasonable accommodation due to a disability. So the governor vetoed that one. In his veto bill, he said that the bill would impose an inflexible 30-day advance notice requirement on the return to work that would not take into account the needs of any particular employer. Businesses, especially small businesses, may have limited employees to staff in-person positions, and the 30-day advance notice requirement of return to work could be impractical, especially in times of critical need or emergencies. I don't expect the author to give up on this one, so stay tuned. It may be back in different form next year. On the next slide, we see another one that was pretty well publicized. This one would have essentially allowed workers who were out on strike to be eligible for unemployment benefits after 2 weeks of leaving work due to a trade dispute, other than a lockout. And essentially, the governor vetoed this one, saying that this would require even greater draws on the already $18 billion unemployment insurance fund deficit, which in turn could result in higher payroll taxes as well. There were a variety of other public policy considerations at play here as well. But the bottom line is this one will not be law come January. Next one. The Displaced Worker Retention and Transfer Rights Bill. This one would have required chain employers, which was defined as a business in California with 100 or more establishments nationally that share a common brand and are owned and operated by the same parent company. So would have required that definition of chain employers to provide covered workers with a displacement notice at least 60 days before the expected date of closure of a covered establishment, and other requirements as well. Essentially here, the governor found that a lot of the aspects of this bill were somewhat arbitrary, and the processes, criteria were overly vague. We have seen, as you will see on the next slide, however, a pattern of bills to try to make sure that employees who are being laid off or facilities that are being closed provide more and more notice and rights to employees. So we will probably continue to see that here in this bill, AB 1356, would have amended CalWARN to increase the period in which the employer must provide notice prior to ordering a mass layoff, and it would have expanded the application of CalWARN beyond industrial or commercial facilities to all places of employment that have employed 75 or more persons in the preceding 12 months. It also would have, in what we have seen as another trend in the past couple of years in the legislature, expanded the types of workers who must receive notice to include labor contractors. But again, that one will not become law this year. Next bill. All right, not the next bill, it's the CLE code. The CLE code is, I believe it's on the next slide. And Brenda, if it's not, I will read it. It is not. Okay, I'm just supposed to read it. It is SS as in Seyfarth Shaw 5471. That is SS 5471. There's your CLE code. Okay, let's go to bills that did not make the cut real quick. We'll blow through those and then we'll get to a couple of questions. So paid sick and family leave. So as Kathy had said, there was an expansion of some of the provisions of paid sick leave, but this one that did not make it through the legislative process would have related to the paid family leave program. So that one did not make the cut. Second one, FEHA protected class for religious observance to include cultural observance was amended to instead only cover state employees' time. And as always, we tell you about these just because we get questions every single year saying, hey, I heard that cultural observance is now protected. So we do this to flag for you that at least, yes, it may have gone through the legislature, but not yet. Next slide. Website accessibility. This one does not relate to employment especially, but it relates to a lot of you all who have businesses that have websites and you provide goods or services to the general public. And you know about, the many website accessibility lawsuits that have been filed over the years. This bill would have and is going to keep going through the process come 2024, even though it was not signed into law, did not go to the governor's desk this year. We expect it to have a better chance of doing so in 2024, hopefully after some amendments. But this one would have essentially adopted a standard for how websites need to be coded in California to be considered accessible in compliance with the law, and done some other things as well. So we'll keep an eye on this one. Next slide. And then we had a bill that would have prohibited employers from subjecting, threatening to subject, as well employees to any form of adverse action for refusing to participate in meetings or communications whose purpose was, and that's a purpose used very, very broadly, to communicate the employer's opinion about religious or political matters. This is the type of legislation that other states have pursued as well. In fact, New York has pursued it more earnestly even than California, but know that at least in California, this bill did not make it through the process this year. The second bill on this slide, the Voluntary Veterans Preference Employment Policy Act, would have permitted private employers to establish and maintain a written veterans preference employment policy, essentially allowing the employers to give voluntary preference to hire a veteran over another qualified applicant. But the bill still said, hey, you still got to make sure that you're not discriminating against people in violation of existing law. Regardless, that bill did not make it through the process in 2023. Next slide. We don't need to talk about this non-compete bill because you all have enough to deal with come 2024 with non-competes as it is, as Kobe already talked about, but know that there was yet another bill, 747, that didn't make it through the process. One other flag on the non-compete front, however, is on November 29th, our non-compete specialists will be having a webinar just about everything that employers need to know about non-compete changes in 2023. We can include information about that webinar with the wrap up to this webinar. So if you haven't already signed up, you can. And I do know a lot of non-compete questions came in after Kobe gave her presentation. So we should have some answers for you in that webinar if we don't have time today. The second bill on this slide that didn't make the cut was a COVID-19 regulatory compliance credit. As much as we'd like to think COVID is gone, it still is being talked about even in the legislature. Next slide. Flexible work weeks. Every single year we see some legislation on flexible work weeks. Every single year it doesn't go anywhere. This year was no exception. We had a spot bill, basically, a bill saying that if the intent of the legislature to do something regarding a 4-day work week, made it nowhere, didn't even get substantive revisions. And then we had the California Workplace Flexibility Act of 2023 that would have allowed employees selected flexible work schedules for up to 10 hours per day without overtime requirement. That also didn't make it through the process. And then, yes, we had another PAGA reform bill that would have made things a little better for employers, but it did not make it through the process either. So with that, you get to see our faces again. Any questions, Kobe or Kathy, that you were able to go through that we can answer in our last couple minutes here?
So there were a couple on the non-competes that we got more than one time. So I'll try and touch on one or two of those, and I'll let Kathy take some of the common questions from hers as well. So one of the questions that we got a number of was whether or not if your non-compete clause is a part of a larger contract, like what does that mean? Is the whole contract void, that sort of thing? And so with that, what you want to take a look at is the underlying contract itself. Do you have a severability provision? AB 1076 contemplates that would just be the non-compete clause potentially that would be invalid. And so, but if the agreement itself as a whole is void, that would be covered by AB 699. So you need to be careful that the whole agreement isn't voided because you don't have severability clauses. So conceptually, it could just invalidate the one clause, but really that's going to depend on the text of the agreement itself. We also got a number of questions about whether or not these bills are going to affect non-solicits and other types of similar restraints on employees. The bill language really specifically focuses on non-competes, but the text of the bill, the underlying conversation around the bill focuses on non-competes, but the text of the bill itself talks about restraints on trade and employment agreements, so it is a bit broader than that. Really, that's probably going to depend on what your non-solicits do with regard to restraining employees. Your typical type of non-solicit is most likely going to still be okay, even in California. If, however, you have employees whose job actually focuses on solicitation, like people that are recruiters, for instance, that's effectively going to be deemed a restraint on trade and a non-compete, and those would likely be unenforceable. The other question we got was about whether or not agreements that were entered into, like, could you still be entering into non-competes with employees outside of California? And the answer to this is yes. So if you have employees that are working outside of California, this doesn't affect what they're doing unless or until they move to California, upon which it would no longer be enforceable and you'd have to notify them that it was no longer enforceable. And the concern for a lot of employers is that, like, if, especially to the extent that you have really highly sought after employees that might be subject to non-competes, particularly like in sales, where maybe you've got a region, like they're covering Arizona, Nevada, California, they're just going to ship the person to California for a couple of months to void their non-compete and then let them go back to their business for their employer somewhere else. So they're going to use this potentially as a way to, like, cleanse people of their non-competes. Now, this is, we expect going to be subject to a bunch of legal challenges, but this is all hasn't shaken out just yet. And then Kathy, I'll let you cover some of the big ones in yours too.
So one of the ones that I wanted to make sure to clarify for people relating to paid sick leave is questions regarding if you've got part-time, temporary, seasonal employees, what their allocation, what their allotment of PSL would be under the new law. So first of all, paid sick leave does apply in California to everybody from full-time to seasonal, temporary, part-time. But because it is supposed to be accrued, although there is a front-loading option, because it's supposed to be accrued as you're working, if you're a part-time employee or a temporary or seasonal employee, you are going to be accruing less than these caps that have been put in place or increased under the new law. So you're not necessarily entitled off the bat to 40 hours or 5 days, the greater of those two, but it's really based on what you're working and what you are accruing. You can just accrue up to that amount. So that, I feel, is an important clarification. We also got a few different questions about the different types of healthcare entities that are covered by the healthcare employee minimum wage increases. So I'm going to go over kind of the broad categories. And if anyone still has questions, please feel free to reach out after the presentation as well. But that bill is covering, obviously, hospitals, clinics. It also covers home health care, which would include licensed home health agencies and a patient's home if healthcare services are being delivered there. It covers ambulatory surgical centers for Medicare participation, any physician groups, licensed residential care facilities for the elderly, county correctional facilities, psychiatric and mental health care facilities, licensed skilled nursing facilities. And within each of these kind of big umbrellas, I know we're at time right now, but within each of these big umbrellas, it parses out a little bit more specifically what is included. So again, if there are more questions on this, please reach out after the presentation.
Yep, and like we said, you'll receive an email that has the deck and a link to the recording, as well as links to our CalPEX blog, of which Kathy and Kobe are editors. And within that blog, we have our ledge update that has links to all of the bills as well. If you want to read more, feel free to reach out to your favorite Cyberark attorney if you have follow-up questions also. But huge thanks to Kathy and Kobe and to you all for joining us today.
Thank you very much.
Thank you.